is not for the government to prefer some ideas or to suppress some ideas. Texas versus Johnson was such an important case to underscore those principles, because at the time, and indeed to this day, public opinion surveys show that there is just about no expression that is more widely loathed and more deeply hated among the American public than burning the US flag, or so-called desecrating the US flag. Now, again, to put this in context for people who might see it as fairly trivial, we have to understand that, like, the day after the Supreme Court held that the First Amendment does protect the right to burn the flag in political protest, despite the fact that it is deeply offensive to presumably the vast majority of the public, that is the offensiveness of the expression, the court said, is a reason to protect it, not a reason to suppress it. That because of this viewpoint neutrality principle, government may never punish speech solely because of disagreement with, dislike of, even loathing of the idea, the message, the viewpoint. The day after that decision came out, the then president of the United States gave a speech denouncing it, and Congress immediately introduced a proposed amendment to the First Amendment to make an exception for burning the American flag. And that amendment came perilously close to being enacted. It requires 3/4 of the states to ratify a proposed constitutional amendment. More than 3/4 of the states have ratified the proposed flag burning amendment to the First Amendment. It requires a 2/3 majority vote in both the House and the Senate. More than 2/3 of the House voted in favor of that amendment. And the last time it came up on the floor of the Senate, it was literally one vote shy of the 2/3 majority. So I think that really underscores that we are talking about a deeply loathed expression. Never before has there been such a groundswell to make an express exception to the First Amendment for any other kind of expression. So that's a vote of no confidence in that particular message. And I'm flipping that around to say that underscores how very, very strongly speech protective the Supreme Court decision was. Take whatever you consider to be the most offensive expression, the most controversial expression, the most taboo word. Those were the analogies in the Johnson case. And those same principles require protecting whatever is considered to be the analogous taboo expression today.